So, good evening and welcome to our first legal webinar of 2024. If you haven't been with us before, I want to welcome you for the first time. And if you've been here before, welcome back. Today's topic is presented, as all our legal seminars are presented, is by Ben Mirza, who you'll see up on your screen, with Mirza Healthcare Law. And tonight's topic is going to be how experienced physicians negotiate employment agreements, and probably a little bit deeper than even that. But again, let me give you a little synopsis. We're going to be doing that. This year's schedule is going to be a little bit different. We're going to be doing a legal webinar every other month. And then we'll be doing with another, a real healthcare practice management person. We'll be doing a practice management webinar every other month starting in February. So we'll have one every month, but it'll be alternating between legal and practice management. So you want to stay tuned for that. The next one will be on February 13th. It'll be practice management, the pitfalls in medical practice management. You want to come in on that one to kind of check out the right things and the wrong things to do. And after we finish with this one, the next one in the schedule is going to be on March 19th by Ben. And that's going to be how to start your healthcare practice. And I will tell you, it's not a matter of even how to start. It'll tell you how to start it. But also, you probably, even if you've been in practice for a while, you probably want to listen to that, because you're probably going to get some tips on things maybe that you didn't do that you should really change and do. And with that, I'm going to really be quiet. I'm going to turn it over to Ben, and hopefully you will enjoy tonight's webinar.
Charles, all right, I am going to put on a screen share now. So, by the way, before I get started, just wanted to say hi to all of you guys. I know there's some names out there like Joy, Hussein, Joe. It's nice to see you guys. Thank you for joining us again. And so let's get started. Okay, so today's topic is how experienced physicians negotiate employment contracts. And I first want to thank you, actually, Charles, for hosting this, because he does this out of the goodness of his heart, just to make an impact on the community. And I want to thank Broward County Medical Association for also getting the word out to their members. And just a quick brief background. I happen to be an attorney that was formerly a CPA. I started off in accounting, disliked accounting, never wanted to be an accountant. Ultimately, I always knew I wanted to be a lawyer. So I started off in the accounting side, did a lot of accounting stuff. So I'm pretty good at like finance and financial statements and figuring out the nuts and bolts of any sort of a deal. And I've just gotten a whole bunch of degrees and worked in a bunch of different places, and licensed really in Florida and Washington, D.C., but my practice is still really in Florida. So that's about it for that. Now let's today we're gonna just keep in mind this presentation is intended for informational purposes only. It's not actual legal advice. It's really just an educational session. You can take some of these excerpts and use them. You could even take pictures while we're doing this, so you can get a feel for what's on the slide. And what we can do is we can actually email it out to you afterwards. If you have a particular question, just feel free to email me. And if you have any questions along the way today, please ask those questions. Unless if the question is a little bit more of a sensitive nature, we will turn off the recording at the end, and then you can ask your sensitive questions maybe after we turn off the recording. But if you have a general sort of a question during the presentation, is probably a good time to ask, because I may not have clarified on that particular topic well enough. So for starters, as you know, there is a PE push that's going on currently. You know that there's corporations that are putting golden handcuffs on their physicians. And I've seen non-compete agreements go anywhere from 5 miles, 10 miles to as much as 100 miles. and I've even seen some non-competes be countrywide, meaning literally excluding the individual from practicing what they do to have to go and operate in a different environment altogether. So that's pretty extreme, rarely ever seen, but it is there, and I have actually had to deal with it before. Yeah. Now, it's normal for an internist to have some sort of like a smaller, or a family practitioner to have like a smaller radius, but when you have a specialty individual, it's usually a larger radius. So we'll touch on that in just a little bit. But so for starters, I just kind of want you to understand, what are the mechanics that are in the background of employment agreements? Who do they really protect? So from the business perspective, what they are looking at is, it's expensive to actually hire physicians. It's expensive to build out an infrastructure that hosts physicians and brings together patients. It's a really expensive proposition to put a a business together. For physicians, what also contracts mean is that they're getting commoditized, and the more commoditized they get, the more restrictions they have put on them, and the more of a burnout they're hitting. For patients, it's really a mixed result. They're supposed to be getting economies of scale, better pricing, better results. But, some patients will argue that, well, they're not getting a better deal and they're not getting better care. And I definitely agree with the part about they're not getting better care just by going more corporate. I think that really still depends on the physician. And the physicians, have a big hand in this. So I do want to actually raise your thought in this area. One is, did you know that as an attorney, I cannot be partners with a non-attorney? So that means that, for example, Charles is not an attorney, so Charles and I could not be partners in a law practice. Now, did you know that dentists cannot be partners with a non-dentist? So they cannot bring in any business people into their practice. Did you know that now there's certain caveats to that, but that's another topic for another day. Now, did you know that chiropractors and optometrists have the same thing, that they cannot be partners with non-optometrists or non-chiropractors? But the people who can be partners with non-licensed professionals is the MDs and DOs. You can thank your lobbyists for that, for opening that hole, and you can also know that if the physicians banded together, they could do a lot more about it, and joining a local association is really ultimately the best place to get started on that. And that's why I support the Broward County Medical Association, Dade County Medical Association, and I'm also the exclusive counsel to several other associations. So I'm a big proponent of medical societies that are at the local level. So today's agenda is really going to be 50 minutes long. We've already cut into about 5 minutes of it, and we're going to talk about strategy for your future employment and how should you be thinking about it. We're going to talk about the different compensation models that are out there. We're going to talk about non-competes quite a bit. We'll touch on professional liability coverage and how that's affected in your employment contracts. And the other thing we're going to talk about is, what do you do before you leave your job? As you figure out your next stepping stone, when you exit, how are you going to exit? And in the end, I will have a link for you to go to find your 15-point checklist. And if you still are a glutton for more punishment, we'll do Q&A at the end. We'll leave time for that, but you can again ask while we're talking and presenting. So let's talk about the strategy for future employment. Oh, any questions so far? If you have any questions, just raise your hand or blurt it out now. So, all right. So what's the strategy for future employment for a physician? Well, there's several different options they have available, and I've got this listed in 4 broad categories. One is to join a small practice group. It could even be an individual practice. None of these particular four categories mean that the compensation is higher or lower. I've seen physicians make a lot more money sometimes in small practices and a lot less money in like larger corporations. So it's not really indicative of money where you end up in any of these areas. I've seen physicians inside private equity groups that didn't get paid a whole lot, and the private equity firms had a ton of money. So it just depends on what the physician wants to do and where they want to be. That's how you end up, going along the lines of what you want to choose. If you like more autonomy, obviously the small practice groups are the way to go. If you like everything kind of done for you and you have less to do, maybe the larger corporations might be a good place to start. But if you want nothing to do with medicine, but bring your medicinal background or medical background to your employment, then you would look at perhaps health plans or managed care organizations that always have in-house physicians that they use, or even private equity groups that are using physicians to help ferret out, projects that they're working on. And last but not least, hospitals. Hospitals are also a pretty good place to get started, but hospitals are no different than actually a larger corporation. They do work a lot like a larger corporation, regardless of whether they are not for profit or research or even a private hospital. So the real difference is you really have three broad categories. The first one is the individual or the small practice group one. The second one in the middle is the large corporations and the hospitals, and I kind of clump them together because they operate in their purposes are very different. Obviously, but the way physicians are treated are similar in a lot of ways. And then last but not least, it's the non healthcare providing entities like the private equity groups or the health plans. So as a physician, you can think about hopscotch or jumping from one stepping stone to the next, either along the same lines of one small practice group to another, or one large corporation to another, or hopscotching between hospitals and private equity groups to small practice groups. So that's what as a physician you should be thinking about as to where you're headed and what are you best suited for. So once you've kind of made up your mind on that, there will also be different compensation models that come your way. Now, the reason why I talk about this, and I find almost zero discussion out on the internet or among even attorneys or even accountants, because I don't think that they want to get into this whole situation. But I obviously see a lot of contracts and I see them designed in different ways. And when they're designed in different ways, I think I need to make you guys aware of it as to what are the possibilities of different compensation models you could ask for. One is a fixed compensation model, which is the one that everybody's familiar with. You get a salary based on an annual salary, a monthly salary, or based on daily rates. Some places will say you'll get $300,000 as a annual paycheck. Others will say you'll get a daily rate of $500. It just depends on what that fixed compensation structure is. Now, there's also the productivity compensation structure, which is usually based on the number of hours, the number of WRVUs that are earned, or on the percentage of collections made. So there's like a fractional percentage of the net collections that are gained from seeing the patients. So like, for example, if you as a physician are netting the practice $100,000 a month, it may be a part of your compensation plan that you get like 3% or 5% or something like that as a part of your productivity compensation mix. Now, that's not to say that it can't get stacked on one on top of the other. You could have a fixed compensation plus combined with a productivity compensation on top of that, and that usually makes for a pretty good deal for all sides, because then everybody gets pretty much what they want. You could also have bonuses get paid on in practice referrals and meeting certain WRVUs. And the fourth item that we have on here is the partnership track. The partnership track is a more dicey as in more unpredictable. Dicey is probably the wrong word, but it's probably more unpredictable way of proceeding. However, that can eventually be a really nice bonus point if somebody is sunsetting their career and they want to bring in a new physician, and they can offer them some sort of a partnership track. But remember, these partnership tracks are usually very, very discretionary on both sides, on the side of the employer as well as the employee that's coming in. And it can also vary based on compensation too. Same thing, you could have it based on percentage of gross profit, not just collections, but actual gross profit or net profit. Meaning, so like, for example, if a physician has a certain staff, so if you're a physician that has maybe one medical assistant, one NP, that's a whole salary structure that falls under that physician. And you may have other cost factors that go into it. So there is a way to build a gross profit model for physicians getting paid. Now, when I use the word physicians, I also mean this can apply to dentists too, and they often do have similar sort of models. But yeah, overall, there is a gross profit model that could be worked out. Now, the whole magic to this lies in how things are defined. If they're not defined right, it could be a real problem. So, like, for example, in the fixed compensation model, if somebody's going to get paid a fixed amount of fee on a per daily or per year basis, well, what do you have in terms of PTO, right? So the paid time off, is that only vacation days, or is that vacation days plus the 10 federal holidays, or is it going to be maybe less less holidays? Some companies only offer like 5 or 6 holidays. Other companies offer like 12 or 13 holidays. It can really vary. And then does that include sick days or no sick days? What happens to CME days? What if you go away for a conference and you are going to go and attend, a conference for CMEs? Does that count against your paid time off? Or is that just added on to additional work days where you're getting paid? So you got to think through these sorts of scenarios when you're looking at your employment contract. The next thing you want to look at is your benefits: health insurance, retirement, disability, and what if you need to take time off. And health insurance and retirement, those are probably the most important ones in here. Disability is also another good one. But health insurance, some employers will pay almost nothing towards an employee's insurance, and the employee has to pay for it while they're on this health plan, and they can always opt out of it a lot of times. While other employers will pay for the entire health insurance plan, whether it's the employee or their family. What I see most common out there nowadays is, that the physician is pretty much covered, or the physician is covered at half the amount of the insurance, and the physician's family, the physician would have to pay for. That's what I'm seeing most often. When it comes to productivity compensation, again, how is that defined, right? Is a production based on the coding, the billing, and how are you going to be doing the tracking of it? Who's going to be responsible for it? Is it going to be based on the amount billed or the amount received? If it's based on the amount received, how do you define collections? If the collections for, let's say, the month of January happen in February and some of it trickles into March or April, how are you going to define that as to the period of cutoff and when you get paid on that? And what happens if you happen to leave the place, and when you leave, like let's say you left at the end of January, what happens to all of the work that you did in January? Will you get paid out the balance of that when you leave? Depending on your employment contract, you could be getting paid after the fact, or you could be getting paid $0 after the fact. So the post-employment effects will really matter when it comes to this productivity compensation bonus. So be careful of that. Also, bonus paid on certain metrics like the WRVUs. Well, how much are you getting paid on a WRVU? Is it like, a small fraction of a percentage of the WRVU value? Or is it after reaching a certain number of WRVUs? Is it going to be after 5,000 WRVUs? Is it going to be after 9 or 10,000 WRVUs? It's really going to vary, and you realistically need to understand from the from the employer is what is a normal amount of WRVUs for the type of services and practice that you have, and what's a good bracket to be looking at, and what's the range, and what's going to happen on that range, and how will you exactly get compensated if you're on the higher end of that range? And what if you happen to be on the lower end of that range? Is there some sort of a negative effect to that? And I've seen that built into contracts as well, where they may get paid a pretty hefty salary, but if they're not performing, if the physician doesn't perform up to the level of expectation, the employer retains the right to pull the salary back. Um, then again, looking at the partnership track, what you want to be concerned about is what's considered a direct expense, what's considered corporate overhead, what's gross profit and net profit. Depending on your partnership track model and how your business unit is being managed and who's helping you manage it, and it's going to depend on how these terms are defined. What's a direct expense? What's corporate overhead? What's gross profit? You're going to want to know that. So like, me as an accountant, I pay very close attention to these sorts of models because I want to make sure that whoever I represent, whether it's the business side or I represent the physician side, that it gets maximized to their favor and they have the most amount of discretion possible. So these are the basic physician compensation models that are out there. Next, let's talk about non-competes. So what are non-compete and restrictive covenants? Before we go on to that, any questions? Any questions? Okay, let's go on to non-compete agreements and restrictive covenants. So just so you know, restrictive covenants is a very broad word or broad terms in the legal world. Restrictive covenants could mean just about anything, frankly. It could be restrictive covenants that apply to land. It could be restrictive covenants that apply to a particular business contract, or in this particular situation, it would be to the employment contracts. But do know that the easements running across your property, the utility lines and all that sort of stuff in the real estate world or the real estate legal world, that's considered a restrictive covenant. It's a restrictive covenant upon the land is how that's looked at. So restrictive covenants can come in multiple ways. One is it's a restriction on the geography. It's a restriction on the type of practice or industry that you're in. And it typically has a time duration attached to it. In the state of Florida, the courts have said that that anything over 2 years is deemed unreasonable. Anything less than 2 years could possibly be reasonable, but it really is going to vary. So my goal for if I represent a practice group, then my goal is to always ask for the 2 year limitation. If I represent the individual physician, I try to get it below a year, and it just depends on what sort of a practice that's at hand. If it's a specialty practice, you navigate through it a little bit differently than if it's a generalist sort of a practice, because a generalist sort of a practice is more dependent on like the local immediate areas, and people get to know those folks really well. Whereas if you happen to be in a specialty practice, well, there are a lot of community referrals that come in, and so you got to be wary of that. And then also people travel a little bit further for specialty practice clinics. Now, what persons or parties can be restricted out? So a physician could be restricted from contacting patients, and even sometimes their health plans. So if a physician happens to be on, let's say, a Humana or a Blue Cross or something like that, I've seen some agreements, they still come up, and they're not that rare. They're a little bit on the rare side, but maybe like 10-20% out there that say that the physician also will not go and compete on the same health plan even if they go work for, let's say you worked in Fort Lauderdale and now you decide to move up to West Palm, it says you won't go and get on the same health plans that you were on in the Fort Lauderdale practice. Now, that's pretty ridiculous. I've never seen it enforced, but some actual employment agreements do say that. Otherwise, there's also the non-solicitation of other employees. So if a physician leaves a practice, they can be restricted from soliciting other employees. So like a lot of much like lawyers, I mean, I like my paralegals and I like my assistants, and I'm very, very particular about them. I'm protective of them, and they take good care of me, and they can actually anticipate my needs. So I like having them. The ones that I'm used to. Same thing for physicians, right? So as a physician, you might have a nurse, you might have a medical assistant that you specifically like. If you as a physician move, are you going to be taking other employees with you when you leave? So there could be restrictions placed upon that. But then there's also ways around that, and we can talk about that offline. Physicians can also be restricted from engaging with certain vendors or all vendors that are unique to that practice. Now, it's kind of hard to restrict the physician on all vendors, including general ones. Like, what do you do with like some of these softwares like Epic? If like Epic happens to be a vendor to the practice, and the physician leaves and goes to another practice where there's Epic, I think that's going to be hard to actually take up in court and say that that the physician is restricted. But if it's a very unique sort of a vendor, it may in fact be enforceable. There's also referral sources that could be restricted. So these are the kinds of stuff that I look for when I go through a employment agreement. Now let's talk a little bit about confidentiality, because that comes right along with the restrictive covenants. A lot of these practices seem to think that whatever methodologies they've developed are unique and informative and can easily be implemented in other places. Well, I'm here to break it to you. Most of these things that are done in this world are really not all that unique, and there are different combinations and tweaks done to the same technology, the same methodology in different places. Nonetheless, a lot of businesses like to think that they have a very unique process, and they may have a unique process, but I think it's just been like temporarily tweaked to match that situation. Now, so that plays a role in this. And also you've got to consider the records, right? So like what happens to the patient records that are in that business practice? If a physician leaves, the business is the one that's responsible for maintaining those medical records, because they are considered the custodian of those records. If there are the records custodian, they've got to follow the obligations that are under Florida law, that they have to follow. So they'll have to do that. So under confidentiality, what people consider are trade secrets and formulas might be unique tools and techniques that they use, and their business records and their patient base that they have. That all kind of falls into what would be deemed kind of unique to that particular practice. Now, remember, if there's ever a fight over any of these restrictive covenants or non-competes, Florida places the burden of proof largely on the former employee that the violation of such an agreement does not cause irreparable harm to the party seeking enforcement of the agreement, or of the employer. So the burden really shifts significantly, even though the plaintiff is the one that has to actually prove it. But once they actually allege it, it changes. It changes. And also depending on how the agreements are written, they can be written in such a sly way that it really does put a lot more a lot more of a burden on the employee. So that's let's talk about a couple of things. One is, when it comes to non-competes, here's the Florida statute 542.335. That basically says you have to have a legitimate business interest in order for you as a business to enforce that upon an employee. So there has to be a set of special facts and circumstances. There has to be that the employee would gain an unfair advantage if they actually use that information after the fact, and that the restriction that the employer was looking for has to be reasonable in terms of time, meaning how long it would last, the area or the geography that it would cover, and the line of business. It's got to be reasonably related to whatever the employer is doing. So it can't be for anything and everything under the sun. And the restriction has to be in writing and signed. If it's not in writing and it's not signed, it's not enforceable. So that's a problem that sometimes the employers have. They'll try to enforce certain restrictive covenants, which just happen to be corporate policies. But if it's not signed and in writing, no, they won't be able to enforce that. That's why it's really important to get that into those contracts exactly the way the employers want it, and the way the physician is agreeable to it. So the statute expressly prohibits the court from considering any individualized economic or hardship that's being caused on the person, meaning the employee. So the statute specifically states that even if you as an employee go to court and you basically say, look, judge, this is going to be an undue hardship on me. I'm going to have to move my wife, my parents, my kids, and everything under the sun just to be able to comply with this restrictive covenant. The statute act says that the court cannot listen to that. So these hardship scenarios that everybody talks about may apply in other states, but in the state of Florida, it's very, very employer-sided. That's why it becomes really important to know what sort of a restrictive covenant you're getting yourself into, how tight is it, and how enforceable is it. Now, I've also seen it where the restrictive covenants are so over the top, and I happen to represent the individual that's going into an organization, that they've actually just signed it only because it's so over the top, it becomes non-enforceable. Like it'll say something like, this restrictive covenant is for 4 years, and that's not going to work. The area that it covers is, let's say all of the state of Florida, and the line of business that they're in is, something like a primary care practice. So they're not going to be able to enforce that covenant on that physician. Now, this is where we'll talk about how Florida is unique, and we'll go back to Florida is unique, and we're going to talk about the blue pencil rule in just a minute. Here's a case law called Humana Medical versus Ira Jacobson. Well, here what happened is that Ira Jacobson dropped Humana and ended up picking up other insurance policies, and he started shifting people over to other plans. But there were certain patients that were looking specifically for Ira Jacobson, the MD, and to them, they didn't care whether they were with Humana or Blue Cross Blue Shield. They still wanted to shift over and go to him. So, what this case law primarily says is that no contract can prevent a patient from seeking the physician of their choice. If the physician is not the one going out of their way to go and contact that patient and pull them and recruit them, even though even as the restrictive covenants tell them that they can't do it. So let's say that the physician is 100% compliant with it, but if a patient comes over anyways, they can take on that patient, because it's that patient's right to be able to get the physician that they want. And this was actually a case out of Miami-Dade County, and it went to the appellate courts, and there is case law on it. So it basically says that non-competes will not be applied to situations that would restrict patient's choice. So, all right, and here's another case, and I wanted to bring this to your attention. It's called Open Magnetic Imaging versus Mirza Nieves. So Miss Nieves, she was actually a physician relations representative, and she had no non-compete. And then one day, the employer came around and said, hey, if you want to continue working here, sign this non-compete. So her argument in court was, I was made to sign this agreement under duress. And that argument actually did not fly with the court. What the court said was, you could have walked away from it. You could have walked away from your employment. You had the choice to do so. but instead you decided to continue working, and in exchange for that, you got compensation and you were treated well and blah, 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 and you signed on that agreement. Therefore, the agreement is enforceable. So that agreement was actually held against Mirta Neves for that 10-mile radius for 2 years. So again, remember, Florida is an at-will state and it is employer sided. So continued employment is deemed an adequate consideration to enforce this restrictive covenant clause, even if it wasn't there before. Now, some of you may have heard that the Federal Trade Commission is, moving to do away with these non-compete agreements. And that's possible that it can do it, but I think that the way ultimately it's going to be decided is if there is a highly paid individual, meaning over certain X dollars, which in the past the bills that I've seen say anything over like 160,000 or even 200,000 is considered a highly compensated employee, that they would be that the employer could put a restrictive covenant on them and make them, obviously have them sign it, and it would be enforceable. So don't hold your breath when it comes to the Federal Trade Commission. Also, you may have heard and you may have seen it on my LinkedIn post, and I've talked about this before. Even in the Florida legislature, very frequently, year over year, there is new legislation that is introduced where it says that physicians cannot be required to sign a non-compete. Now, that sort of proposed legislation goes to committee and usually dies there. It's never really made it onto the floor for a vote, and even if it does, I'm not so sure it'll make it. So again, don't hold your breath that somebody's gonna say that the legislature is gonna save us. The moral of that story, from my perspective, is band together, and you as physicians need to come together at these associations and raise that awareness. I'll tell you where things kind of went wrong for the profession is when people started accepting hotels, dinners, and drinks by their sponsors, and when that happened, it muzzled the physician community from being able to say anything that would be negative or seem negative against their sponsors. So it's important, I say, join the local association and even join the FMA, because FMA is doing the right thing. Again, it needs more support from its physicians to get there. So, all right, so let's continuing on with non-compete clauses and sale of the employer. So sometimes physicians are employed in entities, and those entities are getting sold along the way. But when they get sold along the way, is it an asset purchase or is it an actual merger? So you've got to figure that out first. If it's an asset purchase, was there an assignment clause in the physician employment agreement? If there was an assignment clause that allows for the contract to be assigned by the employer, then yeah, that's assignable, and that's going to be enforceable. So you just got to keep that in mind. But if there is no assignment clause, then it's not going to be assignable and it's not going to be enforceable. Now, if there is a merger that takes place between two entities, by operation of law, the newly created entity or the eventual entity, when two organizations merge, the ultimate surviving organization will have the ability to enforce that agreement. So that's two different types of mergers that are taking place, or sale and acquisition that's going on. One is an asset sale, and the other one is a stock sale. So you got to figure that out in the environment that you're in. What is more likely to happen, and what does my agreement say? Does it have an assignment of contract clause? So you may want to actually negotiate this at the beginning of your contract with your employer and say, look, in case if someone else does take over your practice, I don't want to have that as a restrictive covenant over me, because I don't want my contract to be negotiable. I negotiated away. I want to be able to go out and do my own thing if someone else does take over this practice. So in summary, what are you going to be negotiating for? What you're going to be negotiating for is geographical limits, like how big are they? 5 miles, 1 mile, 2 miles. I've actually gotten a geographical restriction as short as 1 mile before, and in 12 months. So ideally, the shorter you can make all that, the better. Typically, no more than 2 years or less is really what most employers are seeking. Also, make sure that your scope of services is not overly broad, that your scope of work is really specific to what you're going to be doing. So, like, for example, if you happen to be of a particular specialty and you can do, multiple different areas, then ask your employer to be specific as to what you'd be performing. Because if you happen to leave and go down the street and go work for somebody else, you want to be able to work down the street in another discipline or in another area that may be open. So make sure that your scope of services is very specific to what you're going to be doing. Last but not least, you may want to consider putting in a buyout. Like, for example, if you do happen to want to get rid of the non-compete agreement and the restrictive covenants, I've seen buyouts as low as 50,000. I've seen them as high as 250,000. So you may want to consider that as a possible alternative. This is probably a good time to take a picture of this particular slide, because this will help you understand what you're going to be negotiating for when it comes to your employment agreement. If you don't get a chance to, email me and I'll send you this presentation. Now, let's talk about professional liability insurance. A lot of contracts will have in them clauses related to professional liability insurance. And the key part of this that I wanted you to understand is there are two different types of insurance policies. One is called a occurrence form, and the other one is called a claims made form. The occurrence form basically means that even if a claim is filed after the end of the policy period, meaning like if you happen to leave the practice, that it will be taken care of by that insurance company. So an occurrence form of insurance is better than a claims made insurance. But majority of the time, people buy claims made, and they do that because it's significantly cheaper than the occurrence form. But nonetheless, whenever you do happen to pick up an insurance policy, make sure you price out both the claims made and the occurrence form. So a lot of employers will have in it the fact that you've got to provide tail coverage for yourself once you leave that practice. Now, what I've also had employers do, and I've had some of my medical groups do this, is they will provide the incoming physician to recruit that physician with what's called nose coverage. So remember, we said tail on the way out. That's the tail coverage that you need. But on the way in, what they'll do is that group will help the physician get nose coverage, meaning like the nose under the tent, sort of a thing. So that all of their past acts are covered, even if they're working for the new practice. So litigation of non-competes. So there are basically, when you have a non-compete, there's 7 technical ways to defend yourself against a non-compete. And you can always say that the employer breached the contract. And if they did, then you got to come up with as to why they breached the contract or how they breached the contract. I've seen it where people say, oh yeah, the employer is in like a ton of breaches, and they did breaches. And ultimately, as it turns out, there were not a ton of breaches. You got to really figure out what sort of a scenario you're in and what kind of breaches the employer has had. And we'll talk about those in just a minute as to what you could be looking for or what employers need to be aware of so they don't breach their part of the duty. So the other way to actually defend against non-competes is to say that the employer has no legitimate business interest to enforce, that there is no confidential business, there is no goodwill, or there is no extraordinary training that the physician received, or that the patients are coming over on their own. So no legitimate business interest, LBI for short is how it's referred to. That's another way to knock out non-compete agreement claim. Confidential information. Remember, you can say that if you find that the information is not confidential, that it's readily available to the public, then it's really no longer a trade secret. So that's not going to be enforceable either. And remember, restricted periods up to 2 years are okay, but 3 years or and higher is going to be looked at negatively and is not going to be enforceable. Now, there's also the geographic restrictions that we talked about, the scope of work restrictions that we talked about, and remember, there's always the public interest that's in play here. Now, what'll happen is if you're able to prove that any of those restrictions were improper in your contract, the Florida courts will have the ability to what's called blue pencil or rewrite that particular provision of the contract to make it more reasonable. And what should be reasonable. So like, for example, if you had a restrictive covenant that covered for a 100-mile area, and the court says, no, that's not right. What the court will be allowed to do is to do a blue pencil. So if 100 miles is too wide, is something less than that the appropriate thing to do? Is that 50 miles, or is that 20 miles, or is that 10 miles? That's going to be up to the courts, and it'll be at the court's discretion. Now, majority of the time, most of these contracts will read that it's X number of miles as a radius to where you work. Keep in mind that that's as the crow flies, not driving distance. I've seen people make the mistake of calculating driving distance, which let's say it ended up being 15 miles, when in reality, they fell within that, restrictive covenant of, let's say, 10 miles. So driving distance is oftentimes longer than as the crow flies direct distance. And there is a way to do it in Google Maps. You can actually drop pins and figure it out. That's a lot of times what I do when I go through it with my clients. So let's talk about employer obligations. What is the employer's or the practice's responsibility? Keep in mind that the employers have a responsibility to make sure that their communication systems are working right, that the messages are being relayed properly from patients to the employees, to the physicians, that the prescription reordering mechanism that's in place is appropriate and suitable for the type of practice that's there, that the physician is also involved in that whole reordering process, that that the reordering of prescriptions is not done improperly, that there's accurate record keeping. So a lot of times what I tell my physicians to say is, hey, ask for your detailed billing report by NPI number. If your employer cannot produce a detailed billing report by NPI number, I think that there's problems on that. If they're billing out by an NPI number, why can't you get a accounting report by your NPI number? And that's hugely important. You should also ask for a report by location, by physician patients, and all of the other ancillary services that your patient might be picking up along the way from that particular practice. That'll give you an idea of how much value you bring to the particular practice. Now, keep in mind, keep your billing correct. Make sure that there's no kickbacks or anything like that going on, and that neither is your employer offering anybody else kickbacks for sending over referrals. And that's kind of how you make sure that your employer meets its obligations. Now, what activities are considered healthcare fraud? Oh, well, there's actually a bunch of different things, right? So here's some examples from 2023. There was a podiatrist that was convicted for creating a new entity and billing under another doctor's name for his services. So this particular podiatrist did the work, but created a new entity and billed under a different doctor's name. Yeah, so that's illegal, and that happened in Michigan. There was also another case of like the pharmacy billings, where the pharmacy gave out gifts or compensation in the form of rent, office staff, cash, and supermarket gift certificates. That happened in New York just earlier this past year. There was even a DME fraud scheme that was uncovered here in Florida, where two individuals, including a chiropractor and an orthopedic surgeon, they had overseas marketers generate leads and referred the patients to the doctors, and they got prescriptions for braces and got and both billed Medicare, meaning the surgeon as well as the chiropractor and the DME company. They all billed out for those for the prescription component as well as the braces component, and that was just, and they shared in these overseas marketing lead generation sort of things. If you're always wondering about those sorts of news, here's the actual website you would go to, and where you would find news releases about this. So let's continue on with what's considered healthcare fraud. And I realize we're running out of time, so I'm going to keep this short. But these are the kind of things that employers and the employees need to be aware of. If an employee is leaving the practice, are they walking out with something that says something like this, like that the insurance brokers got paid for referring over people to the medical practice? That's highly improper. Insurance brokers should only be getting paid from insurance companies, not from medical practices. Are there diagnostic tests being done where the medical practice was getting paid for all of the diagnostic tests that were being done in somebody else's practice? Also there's sweetheart deals for certain doctors and companies that are in place, and if those sweetheart deals are there, that's a big no-no for the medical groups. They really shouldn't be entering into that. And my medical groups are really pretty squeaky clean, but there are others out there that are not. Also, diagnosing and billing, if there is exaggerated upcoding or unbundling of the billing. There is also value-based care for upmarking MRA scores, medical risk assessment scores. I've seen that happening quite a bit. Billing for patients that were incarcerated. If somebody's incarcerated or out of the country, there should really be no billing going out under that, especially if they're living overseas or living inside a jail cell. So that's got to get looked at really closely. Some people have been known to bill for people like that. The other thing is billing for unlicensed personnel, meaning that the unlicensed individual performs the service, and there is no supervision over them, and it gets billed out under the NPI number of a particular licensed profession. So these are the kinds of things that show up in the healthcare fraud area. There's a whole list of more. I mean, there's even unauthorized locations. The list is long, and I think we're short on time. So I just kind of want to make sure that you're familiar with these in case if your employer or you or somebody is doing something improper, that everybody understands. It's got to be taken care of. If you do have issues along that nature, do call me and I'll help walk you through it. So before you leave your job, here is a 7-part checklist. Reread your contract. Don't just leave your job without, don't resign without having read your contract. Identify what your employer owes you. Ask for the accounting reports, ask for the NPI billing reports. Hold the employer to it. Identify what your employer has done wrong, examples of healthcare fraud, like you can find those examples, and make sure that the employer wasn't doing such things, and don't be held responsible. If your employer is doing something like that, leave. I mean, it's just not the right kind of environment for you, because the employers need to run it cleanly. Now, do keep evidence of wrongdoing in your personal safe, so to speak, because you cannot, although you cannot copy records and all that sort of stuff, for whatever you can keep, make sure that you've kept it in like a safe place. And if you think that this is something you need to defend your license, your professional reputation, then you obviously do have a right to those sorts of records. Now, what to do post-employment? once you do leave, make sure that you've built up already a social media presence, that people know where you are. You could even build like a website that'll say something like, I don't know, drben.com, and so people know where to find you, how to get to you. You could also advertise in the general paper. There's also local papers, like for example, South Florida Hospital News is a local medical paper. So if you want other doctors to know where you're at, South Florida Hospital News, the one that actually Charles has, is a great place to advertise. So with that said, I think we're running out of time. Any general questions at this time? All right. Charles, can we stop the
Yeah,
recording
we
and
can
maybe
stop.
anybody has
Again,
questions?
just to remind everybody about the upcoming ones, you can look at my website and find that information, and we'll stop the recording. And if anybody has any questions, feel free to ask Ben at this time.